Welcome. I'm George Contreras. I'm the chair of the AALS section of Art Law. And welcome to our last webinar session of the year. We're really pleased to welcome you. We have a great presentation today on the case that's headed to the Supreme Court, Cassirer versus Thyssen. We have three experts who will be speaking with us about the case. Emily Bizzotti from California Western School of Law, who was one of our board members in the section of Art Law. Emily Gould from the Institute of Art and Law in the UK, and Zach Clopton from Northwestern Pritzker School of Law. So with that, I believe you see the screen that Emily Bizzotti is sharing, and I will turn the floor over to her.
Thank you, George. So I'm going to start off first with just the picture in question. So on the screen, you will see the painting of Pissarro's Rue Saint-Honoré in the afternoon effect of the rain. Sorry, my French is not very good. So this painting is a series of 15 paintings by Camille Pissarro, painted in Paris from his window. And this is one of his later paintings in his life. So Camille Pissarro was a largely landscape painter, and he painted cityscapes towards the end of his life when he was sick. So this is one of his rare paintings. And so currently this painting is sitting in the Museo Nacional Thyssen Bornemisza in Madrid. But of course, this is far from an ordinary painting. It's steeped in legal battle that is the subject of the Supreme Court case for today, and of course, the subject of this panel. So keep in mind this specific painting as we go through the facts of the case and of the procedural history. So before we get into a discussion, the discussion part of this webinar, I wanted to give a small overview of some of the facts of the case. Of course, the facts are very lengthy, as you see in most Nazi-looted art cases, and stretch from the beginning of the 20th century, but I'm going to try to keep it to a short 5 to 7 minute presentation. So in the early 19th and 20th century, the Cassirers, who are the subject of this case, were one of the most prominent families in Europe and held a large art collection. So they were actually one of the families that helped Van Gogh's art become as popular as it is right now. So Paul Cassirer purchased the painting in the early 20th century, in 1900, specifically directly from Pissarro's primary agent. So Lily inherited this painting in 1926 and displayed it in her home, in her parlor, and her grandson, Claude Cassirer, who began this case, played there as a child. So he remembered seeing this painting in his grandmother's parlor. So in 1939, Lily was forced to sell the painting to a Nazi art appraiser, Jacob Schneeweimer, and she sold the painting for only a mere $360, which of course we know is immensely lower than the amount or the value of the painting. After the war, Lily attempted to recover the painting through military law number 59. So military law number 59 was specific to the US occupied zone, and it authorized victims of the Holocaust to seek restitution of their looted property, which included artworks. So after filing for restitution for the painting in the US, the CORA, so the United States Court of Restitution Appeals, she was successful in that they published a decision confirming that she owned the painting, and they knew that Lily owned the painting, but they didn't know where the painting was. So the painting was considered lost or destroyed during the war. So after the German Federal Republic regained its sovereignty, Lily initiated a claim against Germany for compensation for the wrongful taking of her painting. So while she never received that painting, they did enter a settlement agreement in 1958, which she was compensated for the loss of that painting. And I think the amount was 120 Deutschmarks. And so that's a little bit of the factual history behind it. So in the meantime, while she was still trying to obtain this painting, the work was going quickly through different avenues. So after the Nazis confiscated the painting, it was sold at an auction in Dusseldorf. in 1943, excuse me, the painting was then sold to by an unknown consignor. So we don't know who the consignor was who first sold the painting at an auction house in Berlin. And so this was for about 95,000 Reichsmarks. In 1951, the Frank's Pearls Gallery, which was a prominent gallery at the time in Beverly Hills, arranged to move the painting out of Germany into California and sell the painting to a prominent collector, Sidney Brody, for only $14,000. So in 1952, then Sidney Schoenberg, who is a St. Louis art collector, purchased the painting for $16,000. So we see that the painting is increasing in value as time goes on. In 1976, the Baron, who is pictured on the screen right here, purchased the painting from Stephen Hahn Gallery in New York, which is again was another prominent art gallery, which should have done its due diligence in checking the provenance of the painting. And the Baron purchased it for $275,000. So we see from 1952 to 1976, the painting increased substantially in value. And then in 1988, the Baron created an entity called the Favorita Trustees Limited, which was used to collect and to take care of his vast collection of artwork. So the Baron entity, the Favorita Trustee Limited, entered into an agreement with Spain to loan all of his works, which I think the last valuation was about $4 billion for all of their work, all of the Baron's artworks in general. And they entered into agreement just to for Spain to create the Thyssen Bornemisza collection. So I'm going to call it TBC from now on. And that collection was charged with maintaining, conserving, exhibiting his entire collection in Spain. And so in 1993, finally, the Spanish government passed a law which authorized and funded the purchase of that collection, which included the Pissarro painting. So the TBC paid $350 million for the entire collection. And so during this time that the painting is passing through these different prominent galleries and then finally reached the TBC in Madrid, Lily's grandson, Claude Cassirer, who was a survivor of the Holocaust, was attempting to find the painting, right? He moved to New York and Cleveland after the Holocaust and ended up retiring in San Diego, where I currently am. And throughout this time, he was trying to find the painting and he was unsuccessful until 2000, where technically 1999, 2000, he found where the painting was through a client who told him that it was in the collection of TBC. And so he sought restitution from Spain. So he contacted the TBC and contacted Spain and asked for the painting back. Of course, they denied it and refused to return the painting. He actually petitioned to the Spain's Minister of Education and Culture, who was on the board of the TBC Foundation. So I think there might have been a tad bit of a conflict of interest there, but they did not, they obviously refused to restitute that painting. So instead, because those efforts were exhausted, Claude filed for return of the painting in the US District Court in California. So this was in 2005. So Claude filed under the Foreign Sovereign Immunities Act, which is the jurisdictional act which allows foreign states to be sued in US courts. So it codifies this restrictive theory of immunity, allowing for certain foreign states to be sued if they're not acting in their public capacity, but rather as private citizens, which Zach will get into a little bit later. So under the first Cassirer, so we have 3 different Cassirer cases. So it becomes a little complex. So Claude files under the FSIA under the expropriation exception. So under the certain expropriation exception, this is an exception to immunity for foreign states where property is taken in violation of international law. So at the district court level, the court did find that the expropriation exception was was qualified, and so the painting was stolen from Lilly in violation of international law. The Ninth Circuit found similarly that the painting was stolen by Lilly in violation of international law because at the time the Germans had deprived her of her citizenship. So then we go to the Cassirer 2. So after we go through the district court and the Ninth Circuit appeals, where on remand FSI jurisdiction has been established. The district court then granted TBC's motion to dismiss because of the statute of limitations. So there is a 3-year statute of limitations for replevin action. So under this particular action, the state action for replevin, California has a 3-year statute of limitations, but California instituted a new statute of limitations shortly before this case, which extended the statute of limitations specifically for stolen artwork from museums to 6 years. So here TBC argued both that this was preempted by US policy and that it was a violation of the First Amendment. So the Ninth Circuit ended up denying both of those arguments and held that the 6-year statute of limitations was not preempted by federal law, and it did not violate the First Amendment. And then the issue ended up being moot because Congress enacted the Holocaust Appropriation Art Recovery Act, the HERE Act, which created a 6-year statute of limitations from the actual discovery of a work of Nazi looted artwork. And then we have Cassirer 3, which is the current case that we're talking about today. And so in June 2015, the district court found that Spanish law actually governed the parties' dispute rather than the law of California. So if it applies Spanish law, the doctrine of acquisitive prescription, which is essentially our version of adverse possession, would be used, and in that case, then TBC was entitled to summary judgment. Whereas if California law was used, then adverse possession of chattels is not something that is recognized in California, and the Cassirers would have had title ownership to the painting in question. So now I'm going to pass it on to Emily. I tried to make it a 20-year battle in 5 to 7 minutes, and I think I did it. So Emily, go ahead with, she's going to give a little bit of background about the Nazi looted art regulations and international treaties that impact this case.
Thanks so much, Emily, and great job. What a summary. Like you say, 20 years in 5 to 7 minutes, it's quite a tall order. And as we have seen already, this is a highly complex and technical case. And I have to say, I am absolutely delighted to leave the discussion of those technicalities to my esteemed colleagues on the panel. And as Emily said, what I now hope to do in the next sort of 10 minutes, hopefully no more, is to take a bit of a step back from the details of the Cassirer case to consider some wider issues relating to Nazi looted art and the claims therefore, and to give you a very brief overview of how these issues have been addressed, mainly in European jurisdictions and mainly over the last 20 years or so. I was very struck by one of the parting comments of the district court in the Cassirer case, when in giving its verdict in favour of Spain, it expressed regret at its inability to force Spain and the TBC to comply with what it saw as their moral commitments. And the court's apparent discomfort with its verdict, I think, epitomises the tension at the heart of a lot of these claims for Nazi looted art between the strict application of the letter of the law and the consideration of broader issues of a more ethical and moral nature. Can we have the next slide, please, Emily? So as many of you may possibly know, the founding principles, which for more than 20 years have guided the treatment of Nazi looted art around the world, really, were agreed by over 40 nations on the 3rd of December, amazingly, and very fittingly, today's date, in 1998, so exactly 23 years ago. And these oft-quoted Washington principles, as they have become known, sought to provide non-binding guidance on resolving claims for the hundreds of thousands of works of art looted and misappropriated by the Nazis in the 1930s and 40s from across Europe. So under these principles, states were encouraged to create an environment where claimants could come forward by opening up records and identifying and publicising confiscated art. And at the heart of these principles lies the one I've set out on the slide here, or at least summarised, and that's the principle that where the pre-war owners of these works can be located, states should make efforts to expeditiously resolve these claims via just and fair solutions. And this attempt to reach just and fair solutions characterises many of the systems and processes which have been put in place in Europe over the last 20 or so years. And while the Washington Principles and similar international instruments and declarations which have happened since are not legally binding, I would say that their impact on international norms and on the development of customary practices in this area has been pretty profound. The next slide, please, Emily. So it's acknowledged that in many countries, the search for these just and fair solutions has to take place outside of traditional legal forums, for numerous reasons, many of which were amply illustrated in the Cassirer case. The hurdles to a successful legal claim for those dispossessed of their artworks by the Nazi regime are often insurmountable. So chief among these issues is that of limitation of actions and statutes of limitations, or prescription periods, as they're generally known in continental Europe. The simple fact of the passage of time since the events of the 1930s and 40s giving rise to these claims. And what we might call this technical defence has been used repeatedly by institutions now possessing these works to deny claims from the victims and their heirs. So in contrast to the US system of limitation system of discovery, so the time for your action not starting until you discover your item, and certainly since the HERE Act of 2016, which Emily mentioned, in contrast to that kind of a system, many jurisdictions start that time to bring your action from the moment of dispossession. So, of course, the chances of still existing legal claims for objects taken in the 1930s and 40s in such jurisdictions are negligible to zero. A connected point is this issue of the good faith purchase, again, at issue in the Cassirer case. So works of art looted by the Nazis often moved around quite frequently, passing through numerous hands and jurisdictions, many of which give title to a good faith purchaser. So a transaction in, say, France or Italy or Spain, as we know, operated to transfer legal title to those who purchased in good faith, or sometimes just after a prescribed period of time, thus barring claims by the original owners. In some jurisdictions, further legal hurdles have arisen. So in the UK, for example, the national collections are governed by statutes which provide for very stringent prohibitions against any disposal out of those permanent collections, except in very limited circumstances. And so in the past, certainly, even where those institutions have wanted to accede to claims for Nazi looted art, they've been unable to do so because of those prohibitions. Now that changed in the UK in 2009 with the enactment of this Holocaust Return of Looted Objects Act, which allows those institutions in certain situations to override those prohibitions in order to accede to claims and to return Holocaust looted art to victims or the heirs of victims. And that's Act of 2009 had a sunset clause, so it was imagined at the time that all of these claims might have been resolved within 10 years, but sadly that certainly hasn't been the case, and so an Amendment Act of 2019 has extended the operation of that Act indefinitely. Evidential challenges also work against potential claimants. So most of the original owners of these artworks are, of course, deceased now. And moreover, their treasured artifacts were taken during the chaos of war and persecution, when crucial documentary evidence was lost in many cases forever. And so in that context, proving complex matters such as original title to those works, the fact of the looting, that the current possessor has not acquired title through good faith or any other means, may be more than a potential claimant can realistically achieve. So recognising these legal challenges, because could we have the next slide, please, Emily? Extrajudicial processes and systems have been developed in 5 European states to deal with claims for Nazi looted art. In the UK, the Spoliation Advisory Panel has been in operation since 2000, and its remit is to hear claims by those who lost possession of a cultural object or their heirs in the period 1933 to 1945, where that object is now in the possession of a UK public collection. So the paramount purpose of that panel is to achieve a just and fair solution, taking into account all of the facts and circumstances of the claim. So unbound by legal constraints, the panel focuses on the moral strength of a claim, considering principally how that artwork was lost to the family now seeking its return. So was it directly looted by the Gestapo? Was it sold at an undervalue at the very infamous Jew auctions or Nazi auctions of that era? Was it sold by a Jewish family having to raise money to pay an extortionate tax demand in order to flee persecution? So on the basis of its assessment, the panel has a number of potential resolutions that it can recommend, and these are recommendations only, so its resolutions aren't legally binding, but it's able to recommend a number of options if it feels that the moral strength of the claim is high. It will often recommend that the work be restituted, be returned to the claimants, or alternatively that the claimants receive some kind of financial compensation. In cases which are considered to be at the weaker end of the scale, the panel can recommend that the artwork in question remains with the institution that currently possesses it, but alongside that work is displayed an account of the history of the work, including its history during the Nazi era and the interests of the claimants in that work. So panels and processes to deal with claims have also been established in Germany, Austria, France, and the Netherlands. There are nuances in how the different panels operate, and the path has not always been smooth. Variations in approach have resulted in some instances in claimants receiving different recommendations from the different jurisdictions based on the same sets of facts, which inevitably is a source of some considerable frustration amongst claimants and potential claimants. And even within states, unpredictability and inconsistency in the resolutions come to by particular panels has been perennially problematic. This is perhaps partly owing to the extra legal environment in which these cases are assessed, not based on concepts familiar to us lawyers like legal precedent, but on principles of fairness and morality, which are necessarily very fact dependent and require very nuanced responses. All of that said, the position of claimants before those 5 panels which have been established is infinitely more hopeful than in other countries, and particularly certainly Eastern European countries, where regards to the Washington principles has been minimal or perhaps entirely absent in some cases. So in some states, there's been little progress really since the Washington Conference, whilst in others, arguably, there have been backward steps in recent times, which is something of a concern. To end on a positive note, however, important work certainly continues in Europe. A network of European restitution committees has been relatively recently established. and funding for proactive provenance research into these works increases. An important research project has recently been instigated based at the University of Bonn in Germany to look at international practices in the restitution of Nazi looted art, and it will report its findings in 2024. And just a couple of weeks ago, actually, I read in the art newspaper that the new German government, which is about to take power any day, I think, it has already committed to improving the framework for restituting Nazi looted art by, amongst other matters, eliminating statutes of limitations, creating a central court to handle cases, and strengthening the existing advisory commission. So what is beyond doubt, however, is that despite the passage of more than 75 years now since the end of World War II, there is still significant work to be done. And the journey is far from over, and work must continue to travel the path towards those just and fair solutions first called for by the Washington Principles 23 years ago today. So with that, I think we're going to turn back to more of the specificities of the Cassirer case, and I'll hand over to Zach to do that. Thank you, Zach.
Thank you so much for being here, and thanks to my co-panelists. I've learned a lot from this presentation already. I'm a bit of an interloper in this event. I'm not a scholar of art law. I'm a civil procedure professor, so I apologize in advance for the flashbacks to civil procedure or the putting you to sleep, whichever is your want. But as my co-panelists suggested, these Nazi art cases raise a lot of knotty issues of procedure. And the US Supreme Court is taking up one of them in the Cassirer case that relates to the issue of choice of law. So stepping back for a moment, if you're thinking about choice of law, or sometimes conflict of laws, there are two dimensions, vertical and horizontal. So in the United States, vertical choice of law is essentially the question of whether federal or state law governs on an issue. You can think about this as implicating the Erie Doctrine in those flashbacks to civil procedure, doctrines of preemption, and the like. Horizontal choice of law is the question of which state or country's law is likely to apply. So in a kind of traditional domestic case, you will answer the vertical question, is it federal or state law? And then if it is state law that's going to apply, you have this additional horizontal question of which state's law will apply, California or Texas. And in an international dispute, you might have a further horizontal question. Is it some form of United States law, federal or state? Or is it some form of foreign law from a foreign country? And the issues we're going to talk about here implicate this latter category of the horizontal choice of law. And there, the common approaches to the horizontal question fall into two big categories, which are sometimes called traditional approaches, where you have kind of hard and fast rules like apply the law of the place of contracting or the place of the harm, or more balancing type approaches, often referred to as interest analysis, where the court will consider which jurisdiction has the strongest interest in applying its law to the case. We can jump to the next slide. So we're going to answer those questions not in a run-of-the-mill domestic case or even a run-of-the-mill international case, but in a case arising under the Foreign Sovereign Immunities Act. And as Emily B. suggested, the Foreign Sovereign Immunities Act was an act of Congress adopted in 1976 that codified the United States' view on how lawsuits may proceed against foreign governments. And the way the act works is it says there's a presumption of immunity. Foreign states are immune from suit in US courts, unless one of the following exceptions applies. And there's a list of exceptions defined in the statute that allows suits to go forward. And in this case, in Cassirer, the relevant exception is one for expropriation in violation of international law. But once it's established that an exception applies, the next question is, okay, well, what law governs the dispute between the parties? And the closest thing to a direction in the Foreign Sovereign Immunities Act comes from section 1606, which says that the foreign sovereign defendant shall be liable in the same manner and to the same extent as a private individual under like circumstances. So the question that the courts have to answer is, what does it mean to hold a foreign state liable to the same extent and in like circumstances as the private individual defendant? And that question implicates these horizontal choice of law issues that I mentioned earlier. We can jump to the next slide. So that brings us to Cassirer. And in the Cassirer case, which was filed in a federal court in California, the court had to decide what law governs the issue of the ownership of property. So the case was brought under California state law, this Replevin action. But inside the case, and it's in fact the issue that is likely to determine the outcome, is a question of ownership and one of adverse possession. And this is an issue on which different jurisdictions have different law. In fact, the law of California would suggest that the government of Spain did not obtain proper ownership of this painting, whereas the law of Spain would go the other direction. So the court had to decide which law to apply to the question of adverse possession. And there are two ways that federal courts have thought about this horizontal choice of law question in cases under the Foreign Sovereign Immunities Act. The majority view, the view held by circuit courts outside of the Ninth Circuit, is that the federal court should do in a Foreign Sovereign Immunities Act case exactly what it would do in a diversity of citizenship case. And in a diversity of citizenship case, federal courts apply what's called the Claxon rule. They apply the horizontal choice of law rule of the forum state. So if this were a diversity case in a federal court in California against, say, a private Spanish museum, the federal court would say, we're going to apply whatever law California would choose. And in a case like this, a California court would apply California law on the property law issue. So the majority view says federal court apply the same choice of law approach as the state court in the forum state. And here that results in California law. The Ninth Circuit, however, has developed its own approach. It says, yes, that is true for diversity cases, but Foreign Sovereign Immunities Act cases are different. And instead of applying California's choice of law rule, we're going to apply a federal choice of law rule grounded in the second restatement of conflicts. And under this federal choice of law rule, we would select not California law, but Spanish law on the issue. So the dispute between the Ninth Circuit and the other circuits is on the horizontal choice of law rule to be applied. But that choice in cases like Cassirer actually results in different law ultimately being applied. So it's a choice between state and federal choice of law that results in a different outcome between California law and Spanish law. So the Supreme Court grants cert in Cassirer to resolve this split on the appropriate horizontal choice of law rule in Foreign Sovereign Immunities Act cases. We can advance to the last slide here. So what arguments are being made by the parties in this case? So the Cassirers, who argue in favor of applying forum state choice of law, say, first, we should focus here on congressional intent. And you'll recall that the Foreign Sovereign Immunities Act says, treat your foreign state defendant to the same extent as a private defendant. And here, a similarly situated private defendant would be subject to the choice of law of the forum state. And there is no congressional intent to change the substantive law to be applied. Another way to think about it is that we would want the same law to be applied in a case arising under the Foreign Sovereign Immunities Act as we would in a case arising under another basis of jurisdiction on the same facts. So for example, on the facts of Cassirer, if this painting were not held in a publicly owned museum in Spain, but instead a private collection, the Cassirers say the same law should apply in both of those situations. And that would be applying the choice of law of California. And finally, those who support applying forum state choice of law rules suggest that this approach, grounded in the Supreme Court's decision in Claxon, is important to respect state interests reflected in state choice of law. On the other side, The defendants here and the Ninth Circuit suggest that we should be relying on a federal choice of law rule. And they justify that rule by saying that there are special federal interests in foreign relations implicated by lawsuits against foreign sovereigns. They also suggest that applying a federal rule here would give us the same result, whether we were in a federal court in California or a federal court in Texas or New York. So the majority view, the Cassirer's argument says, give us the same outcome in a federal and state court within the same state. Whereas this alternative argument says, give us the same result in any federal court in any state. And finally, they suggest that the second restatement is just the better way forward, that this is a better way to answer the question, and it would be odd for a court to ignore a better approach. And so those are the issues put before the Supreme Court. We'll get argument on this case in January and likely a decision sometime this spring.
Great. Well, Zach and Emily, thank you so much for that presentation. Now, but before we move on, I just want to acknowledge that Zach and Emily Bizzatti are being very modest in that they aren't announcing that they themselves are signatories to, and Zach was the lead author of an amicus brief in this case. And Zach, you didn't really tell us which side you're on. Which side should win here?
The right side, of course. I filed an amicus brief in support of granting cert, and then we'll be filing an amicus brief at the merit stage on behalf of the Cassirers.
Very good. Well, thank you for all of your work in looking at this and putting together those briefs, which are extremely time-consuming and difficult to do. And it's a law professor's brief, and Emily Bizzatti is also one of the signatories of that brief. So, so with that, let's see if we stop. Yeah, we have stopped. So why don't we go back around then to the beginning and let Emily Bizzatti comment on the comments made by Emily Gould and Zach.
So one thing I wanted to emphasize, which I don't think I brought up in my little speech, is the importance of applying Spanish law to this dispute. So if we apply Spanish law to this dispute, then the prescriptive acquisition, so the adverse possession element, essentially is quite different from our rules in California, as well as I think in most states in the United States, that a thief cannot convey good title. So unlike common law countries, the civil law country of Spain allows a thief to convey good title when there is a good faith purchaser. And so at the substantive level, at the district court and at the Ninth Circuit, one of the main arguments put forth by TBC is that they were good faith purchasers. So the district court actually found that they weren't, that the 3-year statute of limitations in Spain was not applicable because they were not a good faith purchaser. And so the 6-year statute of limitations would apply. And so Spain also has an important rule in which an accessory of the fact, so an encubridor, as they call it in Spain, is not going to be permitted to have this specific exception, this specific special 6-year statute of limitations. So at the merits level, the Cassirers and TBC have been arguing whether or not the TBC was accessory of the fact in accepting that purchase or accepting that loan from the Baron itself. And I think this goes to Emily G's argument when we think about what states should do and what their instrumentality should do when they have these pieces of art in their collections. Should they, as we see in the Washington Principles and the Terrorism Declaration, they should move forward in a way that's going to allow for some of these prescriptive rules to not take over the merits of the case. And I think Emily would agree that these instrumentalities have the obligation under the Washington Principles, the Terrorism Declaration, and I think we have another one in 2022 that's coming up, that to take away the descriptive, the prescriptive statute or statute of limitation to any of these types of procedural limitations and move forward on the merits on the case. So what do you think, Emily?
Yeah, thanks, Emily. I mean, I think this case just shows the huge complexities involved in a lot of these cases. I mean, it's been going on for 20-some years, and it took a lot of time to even get to a hearing on the merits. And I think this is one of the major causes of frustration for potential claimants. And I mean, I think there have been significant steps forward in some jurisdictions. And I know, the HERE Act in the US in 2016, wasn't it, that set the standard uniform 6-year limitation period. I know that it's not perfect, and I know that there've been criticisms about it in some regards, but I think it is an important step forward, and it's I think the case also it brings together so many of the different strands that are frustrating for claimants all over the world. I mean, the good faith issue is one that we see in so many of these cases, but also I guess the sort of stark contrast between the ability to bring these legal claims in the US. And we've seen, since the days of the Maria Altman case for the famous Klimt painting The Woman in Gold, many people have perhaps seen the famous film of the same name from 2015, as compared with, the fact that it is almost impossible to bring claims in court in many other jurisdictions. But to go back to your first point there, Emily, I do agree absolutely that the case also shows the sort of contrast between how far you can get through the law and what still the frustrations are, compared with what is intended by the spirit of the Washington principles. I mean, I've got them here in front of me. I don't know if anybody knows them, but there are 11 very sort of simple, straightforward exhortations really to states to move forward in this area. And the very final principle is all about encouraging states to develop national processes to implement the principles. And I think many people probably would agree that those steps towards implementing those principles in nation states has been sort of sorely lacking in many of those 44 nations who came together 23 years ago to sign up to those principles.
Great. Well, I know I have a ton of questions about all of this, but Zach, did you have any response or rejoinder before we get to questions?
I also had a question, if that would be permitted at this time.
Sure.
Which is that, one thing that kind of got my attention in this case on the choice of law issue is that the outcome would be different if the museum were owned 51% by the government of Spain, in which case you would get this Ninth Circuit rule, or 49% by the government of Spain, in which case it would be treated like a private entity. And what I was wondering from my co-panelist is, if we step away from this narrow choice of law question and just think about the attempts to recover Nazi looted art, does the fact that some of this art is in public institutions and some in private institutions have any kind of impact on how likely it is to recover, what the Washington principles say about the responsibility of states? Does that distinction matter anywhere outside of this kind of Ninth Circuit choice of law rule?
I'll
let you go first, Emily, and then I'll go.
Well, I mean, as far as public institutions are concerned, and certainly in the states in Europe that have been sort of proactive in this regard, there are ethical codes of conduct which behove those institutions to make sure they do their proactive provenance research, to make that research public. So the simple fact for a claimant of knowing where your object might be is a lot easier if that object is in a public institution. And insofar as how the panels actually work in practice, in the UK, for example, the remit of the panel is to hear claims for works which have ended up being possessed by public institutions, and those public institutions then will have to submit to that process. It does have the ability to hear claims for works in private collections, but only if the collector in that case agrees. So both parties agree to that process. And so far as I know, there haven't been any assessments of items which have ended up in private collections. So that's my sort of tuppence worth there. I'll hand over to Emily B for any further comments.
I will say from the US perspective, we have very similar ethical codes for the Association of American Museum Directors and the American Alliance of Museums. So those are the two very important organizations that oversee how museums and museums operate. And so they also have those ethical obligations to do their provenance research and to make sure that they're not exhibiting works that have been looted, regardless of, mostly with Nazi looted art, but there has been also some ethical obligations with pre-Columbian artifacts and et cetera. But we in the United States don't have that distinction with museums. Most of our, I think all of our museums, except for the Smithsonian galleries, are private entities. So for example, when you look at how we restitute works in the United States versus in Europe, it's very different. So a case that just came to mind is the Norton Simon case, which had also been going through litigation for, I think it was 10, 15 years. And it recently terminated with the unsuccessful restitution to the heir. So the Norton Simon Museum in Pasadena ended up being able to keep a work of Nazi looted art under the Act of State doctrine. So within the United States, of course, our courts are much more attractive to claimants, being that we have, better statute of limitations rules, and specifically some of our national policy regarding Nazi looted art. But that private public distinction in the US isn't as important as it is, I would say, in Europe.
Great, thank you. So I mean, I have sort of a series of questions, all of which relate to what is the sort of bigger picture behind this case, and what are its implications going to be more broadly. And so three areas in which that kind of question plays out. I mean, first, we are 70 years since these events, the Nazi era, have occurred. How much art is left in the pipeline that is still subject to these sorts of disputes? And I have no idea whether this is just the tip of the iceberg or whether this is the trailing edge, like this is the last one finally getting put to rest. And then sort of related, well, not really related to that at all. The next question in that implications category is how this case sits alongside the sort of international tribunals and processes that Emily Gould described. If the Cassirers lose in the US at the Supreme Court, are there then other international remedies that they can seek in Spain or in the UK or in some other jurisdiction, or does this US action exhaust all of those under the treaty? And then finally for Zach, it's like, will the outcome of this case have an impact on other types of cases other than Nazi looted art cases or pre-Columbian art cases? Is this an art law decision only, or are there broader implications for, whatever, the trucking industry or, other industries that are out there that are international? So I'll throw that out to whoever wants to sort of leap in first or answer some other question.
I'm happy to make a start with your first question, George, about the sort of continuing scale of the problem. I think I mentioned that when in the UK passed the Holocaust Return of Cultural Objects Act in 2009, there was this sense at the time that, well, surely we're going to have cleared up all of these claims within the sunset period, the 10 years. And that very clearly wasn't the case. I went to, there was a series of 3 quite important conferences in Europe to mark 20 years since the Washington conference a few years back. And there was a big conference in Berlin at the end of 2017-18. And the message there very much was that there is still a huge amount of work to be done. I think they even called the conference something like 70 years and counting. And in terms of sort of sheer numbers, I mean, estimates vary wildly, but I think most commentators suggest that something like 1/5 of Europe's treasures were taken at the time by the Nazi regime in the 1930s and 40s. And of those, I think it's a relatively conservative estimate to say that there are still something like 100,000 still lost. So still out there to be claimed by the heirs of victims. So still a relatively significant problem. And I think the fact of the HERE Act in the US from 2016 onwards might mean that we do see a continuing stream of these cases being fought out in the US courts for a few years to come. I don't know if you'd agree with that, Emily.
Yeah, I absolutely agree. I think the HERE Act and the Foreign Cultural Exchange Immunities Clarification Act, it's a very long name, have created this kind of pipeline that I hope to see more of these restitution cases moving forward. And also in 2018, Congress enacted the JUST Act, which was the Justice for Uncompensated Victims Act, which essentially charged the US government, which ironically to research how other countries are compensating or restituting just property in general. And so not really looking inward to what the US is doing, but looking outward to what other countries are doing. And so perhaps that JUST Act will also help kind of bring to light some more claims that might be out there. But I agree with Emily that I know that there is that the number is at least 100,000 unaccounted for. But when the United States was right after the war going through all of the works in the unoccupied zone, there's just a plethora that wasn't discovered, right? And we still have claims like this that are going to arise. And I don't foresee that this becomes a moot issue anytime soon.
And I'll just say from my civil procedure side of things, I was interested in this issue before I had even heard of the Cassirer case. So I think I would not think about this as an art law issue purely. The Ninth Circuit rule that's challenged was initially articulated in a plane crash case. It applies to all actions under the Foreign Sovereign Immunities Act. And my guess is that if this were just a Nazi art case, the Supreme Court would have been disinclined to take it. The court has been trying to keep its hands out of these cases. But a big thing that we tried to do in our amicus brief at the cert stage was to say this actually has implications for a lot of other kinds of cases. This is just one vehicle to address it.
Okay, and we have a question from Bert Lazaro. Do you want to just say it out?
Yeah, it seems to me that this is the poster child for informal resolution. The defendant has probably spent upwards of $3 million on this case. The plaintiff probably has this on a contingent fee, but the law firm involved has spent very substantial assets in prosecuting the case. If the Cassirers ultimately win, they will not in fact get the Passaro. They cannot afford to have the Passaro because they will owe a substantial contingent fee to their lawyers. And unless I am misreading the newspaper accounts, the Cassirers are not hedge fund operators with unlimited assets. So the Passaro is going to have to be sold, which means that it will end up probably in the hands of some hedge fund operator and out of the public view for a substantial period of time. Now, my hunch is the same as Zach's. That is that the Supreme Court is going to find that Foreign Sovereign Immunities Act cases are much more like citizenship cases, and therefore the same rules will apply. But as I read the current situation, the result of that decision will be to send the case back to the district court for renewed examination of what California choice of law would actually be. And once that goes back, either Judge Walter will continue to adopt his view that California choice of law would choose Spanish law, or might change his view in the light of whatever subsequent choice of law decisions have come down in California. Then there's another question to be decided, and that is, what is the California substantive law on the question? And it is not at all clear that the HERE Act resolves the question of the statute of limitations, because no one has litigated the question of whether you can lengthen the statute of limitations to the detriment of someone for whom adverse possession has already occurred. So $3 million in legal fees is just a starter here.
Any responses? That's quite a lot packed in there. Thank you for that, for the analysis.
I think I'll just respond to that. I mean, Bert is completely right. The Supreme Court could say that state choice of law rules apply, and then at the district court level, they could find that Spanish law is the applicable law. Most of the amici have been arguing that Spanish law should not apply because California and the US have specific interest in these types of cases based on the HERE Act, based on the Clarification Act, based on the Holocaust Recovery Act. We have and California in particular has a specific interest in restituting in restituting Nazi stolen art, as they created their own statute of limitations for art stolen. So I think it would be an argument that the court could make that Spain has a better interest or has a stronger interest. But I think most of the amici have agreed that California's interest by far is more than Spain's interest. So that's all I'll add to that.
Okay. Any final comments or words from Emily Gould or Zach before we wrap it up? No. Okay, well, we're at the hour, so that's all we'll have then. Thank you so much for the presentation, the analysis, and the discussion. We'll be looking forward to the oral arguments in January, and hopefully a decision soon thereafter as the saga continues. So the recording of this session will be available on the AALS YouTube channel, and we'll send a notice to the listserv for the art law section once it's up. And thank you all for attending, and we look forward to seeing you in just a few weeks at the AALS annual meeting when the art law section panel on permissions culture will be part of that meeting. So thank you all very much. And we'll end the recording now.